Good morning.
I was punctual, Judge.
Huh?
I was here at 8:50.
Oh, hey, I love it.
Good morning.
Good
Daryl.
morning.
How are you?
All right, how's it going?
I'm good. Well, thank you.
All right, the court is calling 2025 CR 014033, State versus Marvin David Granados Acosta. Can I have parties announced for the record?
Megan Galloway for the state.
Roberto Vargas for the defendant, ready to proceed, Your Honor.
All right, and we have an interpreter here. Could you raise your right hand?
Now size you're on.
All right, thank you. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. And are you Marvin David Granados Acosta?
Yes,
All right. All of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
yes,
All right, and counsel, do you speak Spanish?
Yes.
And do you speak it fluently?
No, but I speak it now.
All right, and were you able to go over these documents with your client in Spanish?
Yes, Your Honor.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, Your Honor.
The court will find that the state is in compliance with discovery. Are there any applications in this case?
Got it.
Mr. Acosta, did you review the true bill of indictment with your attorney? Did you understand it?
yes,
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, Mr. Acosta, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
yes,
You're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
yes,
You have a right to jury trial, a right for you and or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter a plea in this case?
yes,
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Acosta, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
no,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to your plea bargain agreement, punishment is to be assessed at 135 days in the Bexar County Jail under 1244. There's an $800 fine. Did you understand that to be your plea?
yes,
State, is that the plea?
It is, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
yes,
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
yes,
No, do you plead guilty, not guilty, or no contest?
I plead guilty.
State, any evidence?
State offers states one in attachments.
No objection, Your Honor.
State, you may be excused. Did you review the stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, but prior to sentencing, may I put something on record?
Yes.
Just for the court to know, Your Honor, I did advise my client of his immigration rights. He's not here legally. I did have the assistance of the immigration attorney from the MAC office. I just wanted to let the court know.
Right. All right, the court will follow your agreement, sentence you to 135 days in the Bear County Jail under 1244. Give you credit for any time served. There's an $800 fine. Time and money will run concurrent, and there's to be no re-entry into the United States. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? With your attorney, did you understand it and sign it in both places?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you.
Your Honor, before we go off record, can we modify that? He can be permitted to come back in this country if he does it legally.
No, because they're not gonna let him back in.
We might not know 10 years immigration law might change.
Well, I'll approach that at that, I'll consider that at that time. And my understanding, counsel, and if it's incorrect, let me know. My understanding, did your client have something in federal court?
No, because he would be there first.
No, I have that he was sentenced in federal court. That's why this was recalled for the 20th.
No, I was in federal court, Judge.
Okay, all right, thank you. Oh, you were in federal court for a sentencing.
Yes.
Okay, all right, thank you.
Thank you. May we be excused?
Yes.
Okay. Thank you, Judge. Thank you.
Thank you.
My
Thank you.
pleasure. May I be
Yes.
excused?
Yes, always great seeing you.
My pleasure, always.
Who's here on Joe Hernandez?
Morning, Judge.
Good morning. What page is Joe Hernandez on? Okay. Last page. All right, the court is calling 2024 CR 012898 State versus Joe Hernandez. Can I have parties announced for the record?
Brandon Prater for the state.
Alexander Cross for the defense.
And are you Joe Hernandez?
Yes, Judge.
Counsel, are there any applications in this case?
Sorry, Judge.
Are there any applications?
No.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Judge.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Judge will be waiving the enhancement and proceeding as charged.
Any objection?
No.
Mr. Hernandez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
All right, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and was.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported and denied naturalization. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 254 days in the Bexar County Jail under 1244. There's an $800 fine and there are no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is.
State, is that the plea?
That is a plea, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Judge, we offer state exhibit number 1 and all of its attachments.
Any objection?
No.
State, you may be excused.
Thank you, Counsel Judge.
Okay. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence. Just one moment. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your
Anything you wish to say on behalf of your client?
Honor. Just that this is an older case, Your Honor. He's been clean for some time now. He's got a place to live and he's got a place to work.
Oh. So have you maintained your sobriety?
Going to AANA.
Oh, that's good. That is great. I'm so glad you've gotten it on track, okay? All right, this is what the court will do. The court will follow your agreement. The court will sentence you to 54 days in the Bexar County Jail under 1244. There's an $800 fine, time and money run concurrent. Is this a judgment satisfied?
It is, Your
All right. To the clerks, they gave you this number and said that's a judgment satisfied?
Honor. Yeah, well, that's the days that he has actual credit in Bexar County Jail.
Okay. All right, thank you. I always ask that question because sometimes people think they're getting out because they have 3-for-1 or 2-for-1. I'm not in charge of 2-for-1 or 3-for-1s. The only thing I can tell you is if you've served an actual 254 days at the jail, then I'll give you credit for that and it will be a judgment satisfied. All right. So the court will sentence you to 254 days in the Bexar County Jail under 1244. Give you credit for any time served. There's an $800 fine, time and money to run concurrent, and the court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney, okay?
Yes, Your Honor.
All right, we can go off the record. Stay on track with what you're doing, all right?
Yes, ma'am.
All right, thank you. Have a good one.
Thank you.
Thank you. All right, All right, just a moment. They approached me on Simon Garza. All right, who's here on Simon Garza? Let's see what page this is on.
I think it should be page one, part of the job.
Thank you. All right, the court is calling 2025 CR 004128 State versus Simon Garza. Can I have the parties approach and announce for the record?
Judge Brandon Prater for the state.
Marissa Giovanco for Mr. Garza. And he is present.
All right, and are you Mr. Garza? All right. I've received this request for a continuance. Why should I grant a motion for continuance? Because this case has been going on since June. Everybody said there was a plea deadline date on October 16, 2025. And everybody agreed to a jury trial date of January 20th. So what's the issue?
Judge, I believe that, well, first, my medical examiner will be unavailable for trial this week. He'll be testifying in another county. And I believe that Ms. Giovanco has subpoenas out for discovery that have not been returned to her. I don't believe that we could proceed forward without that discovery, and the defendant wouldn't be able to get a fair trial.
What discovery?
Judge, I don't believe that I'm obligated to say that as my defense.
Well, you put that there's good cause in your agreed motion that is not sworn to. So, I mean, I need some reason for a continuance, and it's the defense that's asking for a continuance, not the state.
Well, Judge, it is an agreed motion. I did prepare it, but it is an agreed motion. And I also need the medical examiner here for our defense. He
Well,
is detrimental to both sides.
here's the thing. If y'all want a motion for continuance, y'all need to put that in the motion for continuance. Because otherwise, y'all are doing an oral motion for continuance, and you're asking me to grant a motion for continuance, and y'all are not telling me anything. And it needs to be in writing legally.
Okay.
So if y'all want to put that in writing and state if you want to file a motion, or if you want to add to your motion for continuance and put that in there, then you all can put that in there. And then I'll hear it.
Okay, thank
Okay,
you.
Okay, thank you, Counsel.
you're welcome. Who's ready? Okay.
Not working today.
Oh, no, I hear you. All right, who's here on Isaiah De Los Santos?
I am, Your Honor. Eric Wolf.
Okay, come up, please.
Thank you, Your Honor.
Sorry, Odyssey is taking a while to pull up your case.
I say when I pass away, my tombstone is just gonna have one of those symbols of waiting.
You know what, and I tell you, a lot of people now, at least I've seen, where they're doing QR codes so you can see their life or something. I'm like telling everybody, just cremate me, get it over with.
I know you're not a fan of tattoos, but I always thought QR code, that way your tattoo can change, you know?
Yeah. Now, I just think tattoos would be very painful. Okay. All right, I have this, but I don't have. I need the actual motion to revoke. No problem. How do you pronounce your first name?
Isaiah.
Isaiah.
They just
Okay.
spelled it like that.
Okay. I'm just waiting for the motion.
Right now. So I
You can use yours for now then.
Sorry.
All right, who's the prosecutor on Isaiah De Los Santos? All right, court is calling 2023 CR 3928, State versus Isaiah De Los Santos. Could I have parties announced for the record?
And Eric DeWalton, I represent Mr. De Los Santos.
And are you Mr. De Los Santos?
Yes, I am, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did.
Are you the same Isaiah De Los Santos who was placed on deferred adjudication in 2023 CR 3928 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on February 8, 2024 for a period of 6 years? Is that you?
Yes, sir.
All right, state, you may proceed.
Violation of condition number 4 in Bexar County, Texas, the defendant Isai De Los Santos did then and there fail to report to the supervision officer as directed for the months of March and April 2024 in violation of condition number 4.
How do you plead to that, true or not true?
That's true.
And we waive and abandon the remainders, Your Honor.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
I do, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking that you revoke the defendant's community supervision and sentence him to a term of 5 years in the prison. And that is due to the violation which was pled true to that the probation department has not heard from the defendant since February of 2024.
All right, in defense, what are you requesting?
Your Honor, I'm requesting that that you deny the MTR and continue him on, and I would like to discuss options,
All right,
if I may.
so I'm going to need to know why he didn't report.
Yes, Your Honor. When I took over the case, I saw what he was charged with. He's facing a second-degree felony, and I came up to with my client, not expecting to know what was going to come out of his mouth. He readily just came out and said, Your Honor, his 2 children moved to Abilene. He hadn't seen them. He chose to see his children over probation, which is, he knows. That's not an excuse. We'll get into that. Absolutely not. He ended up working his way back to San Antonio. I asked him if he turned himself in. He got pulled over for a traffic violation. He has no priors and he didn't pick up anything new, but he hasn't done anything since. I know this is a crazy argument to say he hadn't done anything, but I know he would like to address the court. And when I spoke to him, he was very genuine to me. And I said, basically, you're going to be making your own argument to the judge.
All right, do you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
I'm Isaiah De Los Santos.
All right, somebody needs you to speak up, 1, so I can hear, because I have allergy ear, and so the court reporter can hear, okay?
My name is Isaiah De Los Santos.
All right, so what would you like to say? And of course, you know, I want to know
Yeah.
why you've disappeared. And it appears, since the dates on here are from 2024, it
Mhm.
appears that you've been missing
Well,
since 2024 of April at least.
That's correct. When I was before signing probation, I was 3 months in Bexar County Jail. So when I got out, I was trying to look for my kids and found out they moved 500 miles away from San Antonio. So I made an rational decision to go see my children.
All right, that still doesn't explain to me why you didn't contact probation, because your attorney will tell you. Usually when people have things, employment, or there's something with their children, or you can always ask permission from the court, and then I will hear it and either I'll grant it or not. But it appears nobody knows where you are.
I know, I just made an irrational choice. I really, I guess my father instincts it was just more of seeing my children than like, I really didn't think about it, right?
So did you see your children?
Yes, I did, ma'am.
And when did you see your children? What year?
Same year, but I want to say a couple of months after going to Abilene.
So you're saying like June
Yes,
or
ma'am.
July 2024, that's when you saw your children? Okay.
How many children do you have?
I got 2 children.
How old are they?
Right now, one of them 16 and one of them 17.
Are you employable?
I employ, yes, I am.
What are you asking of this court?
Just to be sympathetic towards me and my father instinct, you know, I know that,
You know the court isn't gonna award you for just disappearing, correct?
yes,
But you haven't picked up any new cases.
yeah,
Have you been using any drugs?
no drugs.
Are you clean?
Yes, sir.
How long have you been waiting for this MTR? About a month?
A month.
Okay. Anything the court puts in front of you, if they put an ankle monitor on you, if they have a cognitive thinking course, anything they put in front of you, are you saying you can do it?
I can do
Are you asking for this judge for one chance?
one time.
Some
Yeah.
type of remedy for your bad decisions?
That's like,
Yes.
Okay, Mr. De Los Santos, so when you were placed on probation, you provided an address of 1107 Lavetta Boulevard. For renting that
Yes.
location? Okay, and so when you were released from the Bear County Jail, did you report back to that location before going to Abilene?
I only reported like back to that office for like 2 or 3 days.
Okay, so you lived there for 2 or
2 or
3
3
days
days.
after your
Yes, ma'am.
release and then went to Abilene.
And then I went to my mother-in-law's house there in San Antonio.
Okay,
And that's how I found out my kids had moved, my children had moved to Abilene, Texas.
okay. And so I guess you understand that the reason you have to provide that address is so that probation can get in contact with you if they need, right?
Yes.
And so when you're placed on probation, you also have to provide like phone numbers and stuff for probation to be able to get into contact with
Yes, ma'am.
you. Is that correct?
That's correct.
Okay, and so in this case, you provided probation with, I guess your girlfriend at the time's number. Do you recall that?
I do.
Provided to them so that they can get in contact with you, right? Okay, and then also, your mother, do you recall that,
Yes.
Janina? And then also your grandmother, is that correct?
Yes,
Okay, and your brother, right?
my brother.
Okay, and so are you aware that the probation department made contact with all of these people and none of them were able to tell probation where you were?
Yeah,
Okay, so did these people know that you were in Abilene or?
no,
No?
No,
Okay,
ma'am.
so you just left the city without telling your family?
yes,
Okay, and then you were picked up back in San Antonio, is that correct?
yes, I came back here to fix this
Okay,
problem.
okay, but you never contacted probation, you were just picked up on a traffic
Yes.
stop, correct? Okay, we talked about it too.
Any other questions?
No, Your Honor.
All right. I want you to know that I've heard the argument that your counsel has put forward and that you have put forward, and I've internalized that. You entered a plea bargain agreement, and according to your plea bargain agreement, it was count before silent, right? And the court granted you deferred adjudication. At that time, I listened to your previous attorneys, their argument. But you haven't done anything on probation. That's a problem. And it tells me that maybe probation is not good for you. So I'm going to grant the motion. I'm going to find you guilty and I'm going to revoke. The state is saying they're requesting 5 years. Defense, what are you requesting?
Your Honor, I would respectfully request the court to consider 2 years.
This is what the court is going to do. The court is going to sentence you to 4 years in the prison, give you credit for any time served. There's to be no residing in households with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
That's your signature.
Oh, that's yours.
Oh, sorry.
Sure, no problem. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you, okay?
Thank you.
Thank you for consideration, Your Honor.
You're welcome.
The hearing begins like countless others, quiet and procedural, with the defendant standing before the judge expecting nothing more than routine paperwork and predictable consequences. He answers the judge's questions calmly, confirms he understands the charges, and agrees that he has reviewed every document with his attorney. To anyone watching, it appears this case will move quickly, without drama or resistance. That assumption turns out to be dangerously wrong. As the judge walks through the plea, the seriousness of the charge becomes clear. This is not a minor issue or a symbolic slap on the wrist. The judge carefully explains the possible punishment, the rights being waived, and the long-term consequences attached to a felony conviction. The defendant repeatedly says he understands, but his body language suggests confidence, almost relief, as if the hardest part is already over. Then the courtroom energy subtly shifts. The judge reviews the evidence and pauses, no longer rushing. Each confirmation from the defendant locks the plea into place. There is no walking this back now. When the judge formally finds the defendant guilty, the room grows silent. What once felt routine suddenly feels permanent. In a separate but equally intense moment, another defendant faces the court for violating probation. This time, there is no plea deal waiting to soften the outcome. The judge listens as the defense explains why the defendant disappeared for months, choosing personal decisions over court-ordered supervision. The explanation is emotional, involving family and regret, but the judge remains focused on accountability rather than sympathy. The judge makes it clear that probation is not optional and that disappearing without permission undermines the entire justice system. You don't get rewarded for vanishing, the judge explains, calmly but firmly. Despite acknowledging the defendant's honesty and lack of new crimes, the court concludes that trust has been broken beyond repair. The final ruling lands hard. Probation is revoked. A prison sentence is imposed. The defendant stands silently as the weight of his choices becomes real. There is no shouting, no theatrics, just the unmistakable sound of consequences closing in. By the end of the session, one message is crystal clear. Court is not a place for assumptions, shortcuts, or wishful thinking. Every signature matters, every missed report matters, and every decision follows you back into the courtroom. This case is a reminder that justice doesn't always explode. It often arrives quietly, decisively, and without mercy.